The second key duty that we want to deal with is that of due care and diligence. Now, due care and diligence is technically a fiduciary duty, but really it emerged before there was such a thing as negligence. So I'm not going to classify it as fiduciary. I'm going to treat it as something different. It's a combination. You also can be found to be negligent in your activity, but care and diligence really just means that you're applying yourself with the care and diligence required when you undertake an act. So most often what you will see is care and diligence is applied to some other function. So if you have to, say, sign off the accounts like the directors did with Centro, you have to do that with care and diligence. And the breach is not taking that care and diligence. Okay, so let's have a bit deeper look at this particular duty. The actual test for care and diligence is set out in section 180 subsection 1. And what we can see is that it's a reasonable person test. That means it's an objective test. It's not about what that director thought they should do, which would be a subjective test. It's an objective test. But notice that it's an objective test, but for want of a better term, with a kind of subjective or moving kind of measure of what care and diligence is, because it's what a reasonable person would do if they were a director or officer in the company's circumstances holding the same position and responsibilities. So what that means is for different kinds of companies, or companies, say, facing crisis, we would expect a director or officer to take more care and diligence if they're facing crisis, or in specific circumstances, like if it's your local knitting club, you'd expect less care and diligence than if you're a director, say, of BHP. So what we can see is this expectation varies by the company's circumstances. It also varies by the position and responsibilities of the people. So, for instance, we would expect is that a CEO would have greater care and diligence than, say, a non-executive director. Okay. So, and the reason for that hopefully is obvious, that the position of being a full-time key employee, the main leader of the organisation, is different to being a part-timer. And one of the most interesting things, I think, legally, is that courts are more and more looking to things like letters of appointment, right? So they look at the letter that maybe appoints a director. Now, if that letter of appointment mentions something like the financial acumen of a director, then you can make an argument that that's part of the position of that director, and therefore you have an expectation of care and diligence around finance. We also see positions and responsibilities, say, being on a committee or being the chair or chair of a committee, and there's a famous case about that, the Greaves case, which goes into that. And I think to be prudent, without it being established law, I think just to be prudent, you could expect that a reasonable person would think a chair would take more care and diligence than, say, other particular directors. But again, highly contextual. It's going to come down to the specifics of the case. Just to reiterate, this is an objective test. It's what the person on the Clapham omnibus would think, not what the director in the specific situation actually thought was taking care and diligence. Again, subjective level of care and diligence according to the company's circumstances and the position and responsibilities that the individual held. Now, for a lot of historical reasons, which I won't bore you with, directors became worried that people would not take risks because they became being held, were seen to be being held more and more accountable for poor decisions. There are a couple of reasons for that. One of them was the Corporations Act stopped companies to allow having a waiver for negligence in their constitution. So that meant the law hadn't really changed that radically, but the ability to put a waiver in the constitution had, so a lot more people were getting sued. So as a result of that, in a very famous case called the AWA case, people started thinking about, well, what should we expect a director to do? And to try and help risk taking, because remember, the ability to limit liability right, is one of the key functions of the company, and to take this commercial risk without putting the shareholders at risk has fueled the modern economy. So what you don't want is the directors not wanting to take that risk when it's unreasonable, right? When they're taking a reasonable risk, we want to encourage that. So what Parliament did was come up with a defence for care and diligence, and it's in section 180 subsection 2. Let's have a look. So this defence for due care and diligence is called the business judgment rule. Okay. So first thing to note is that it's actually about business judgments. It's not about any other kinds of decisions. And so if you're making a business judgment, you meet the requirements of 181. That is, you've met your due care requirements, right? And your common law and equity. So it meets all your due care and diligence requirements in any form of law if... Now what's really interesting here is that fiduciary... There's a lot of fiduciary or self-dealing elements to this defence. So the law is really strict about not being a self-dealer when you're in the role of director or officer. So what they do is reinforce it in the defence. So if you make a judgment, good faith for a proper purpose, remember that's 181, right? And you don't have a material personal interest, 195. Okay, so what we're seeing here is if you're self-interested, you can't use the business judgment rule as a defence for due care and diligence. So it's another reason to reinforce that element about dealing appropriately when you're conflicted. Here is the real kicker for the defence, that you inform themselves about the subject matter of the judgment to the extent they reasonably believe to be appropriate. Okay. So what do you have to do? Well, if it's a big bet the company decision, you would expect a director or officer to take a great deal of care and diligence. If it's a small matter, not so much. Again, there's a changing line here about the care and diligence, but the key is that directors need to be informed about the decisions that they make. And there must be some rational basis for believing it's in the best interests of the company. Okay. So if you do that, you will have satisfied your business judgment rule. Be informed. There's a rational link between your decision and the long-term interests of the company. Over the last few years, there's been a number of cases that have developed due care and diligence. In fact, over the last century, 150 years, the expectations of care and diligence are something that has shifted. That fiduciary role, the self-dealing role, hasn't shifted. The courts have always been very strict about that. But once we move into this idea of applying yourself to the task at hand, I think the community's expectations have changed, and with it, so have the courts and their expectations. So if you go back, there was a famous case, I think it was the Malaysian rubber plantation case, where the judge said you can be an idiot as long as you're an honest idiot. And so what the judge was reinforcing was don't be self-dealing, right? You don't need to apply yourself. And we could talk about the Cardiff Savings Bank case, but I won't bore you with that detail as an example of where you really didn't need care and diligence. Okay, things have changed. You do need care and diligence. In fact, it's gotten to the point where I think that there have been a number of cases here, which we have on this particular slide, which have shown that what's the level of this information? How informed do you need to be? Well, if I was to kind of put a little trite saying around it, is you need to be in a position to question the information and advice. You need to dig down into the assumptions, right? So with these particular cases, in the Vines case, it was about not questioning, right? Some calculations from experts. Okay, so it's just about questioning, not being right or wrong. The same in Centro. There was unquestioned reliance on experts, right? When the law required, because what they had to do was sign the accounts, and the law required that directors do it, right? And the fact that they had unquestioned reliance, not that they weren't allowed to delegate, but they had unquestioned reliance. And in the James Hardy decision, again, it was the fact that in that particular case, the board didn't question the advice of experts. And really, I think the expert advice was almost a bit too good to be true. right? So the courts are saying you really need to question that expert advice. And so that rounds out our second major duty, that of due care and diligence. What we're going to do now is have one final little video about the other areas and just explore a couple more details about those two core duties that we've dealt with.